Good morning. This meeting will come to order. This is a public meeting of the Commodity Futures Trading Commission to consider issuance of proposed and final rules under the Dodd-Frank Act. I'd like to welcome members of the public, market participants, and members of the media to today's meeting, as well as welcome those listening to the meeting by phone and watching the webcast. During today's meeting, the Commission will consider 2 proposed rules and 3 final rules. Specifically, we'll consider proposed rules related to customer clearing documentation and timing of acceptance for clearing, and a related clearing member risk management rule. We'll also consider final rulemakings with regard to the process to review swaps for mandatory clearing, a second process rule, but it's called a process for registered entities rule submissions, or what the industry sometimes calls Part 40, and removing references to credit ratings in some of the Commission regulations. Before we hear from staff, I'd like to thank Commissioners Dunn, Summers, Chilton, and O'Malley for their significant contributions to the rule writing process. I also want to pause and give a hearty congratulations to Commissioner Bart Chilton, who became a grandfather, I guess, a few hours ago. And a young baby boy, Connor Thomas, we understand is healthy. And so Bart, I think, has left his proxy for the various matters today. But terrific. Bart Chilton is a grandfather. I also want to thank, yeah, we're just all thinking about that. No cheetah traders for that poor Connor, though. I also want to thank the hardworking staff of the CFTC for their efforts to implement the Dodd-Frank Act. This week's the 1-year anniversary of the Dodd-Frank Act, and on this anniversary, it's important to remember why the President and Congress came together in this historic way. The financial crisis was very real and happened in part because the system failed, the financial system and the regulatory system failed, and when AIG and Lehman Brothers failed, we all paid a price. The Dodd-Frank Act included critical swaps markets reform to protect the American public, and the law brings much-needed transparency to this marketplace and reduces the risk that swaps pose to the overall economy. While they are important, I would say, essential hedging tools for end users, they also concentrated risk and led to the possibility that taxpayers might stand behind large financial institutions. Since the passage of the Dodd-Frank Act, the CFTC has been working diligently to write rules to implement swaps provisions of the law to ensure that swaps no longer operate in the shadows and financial institutions pose less risk to taxpayers. And we've substantially completed the proposal phase and have now turned towards final rules. And we're going to take these up in public meetings as we have another one in early August, and we have 2 scheduled for September, and no doubt we'll probably schedule approximately 2 a month after that. And take them up when staff is ready to submit a recommendation and when the commissioners all have sufficient time to give feedback to the staff on those and bring them to full commission action. But until the CFTC completes its rule writing process and implements and enforces these new rules, the public remains unprotected. Many will get the benefits of swaps, but will still have less transparency and greater risk than the Dodd-Frank Act envisions. Before we hear from staff on the rule writing, I'd like to turn to my fellow commissioners. Commissioner Dunn.
Thank you, Mr. Chairman, and let me start off with my congratulations to Commissioner Chilton on becoming a grandfather. It is truly, for you younger folks, one of the real joys in life to become a grandfather. My 2 grandsons, Sam and Aiden, are a constant source of joy, and when you get to be Bart's age and my age, you'll get to be part of that. I want to thank you all for joining us today for our second meeting to consider final rules promulgated pursuant to the Dodd-Frank Act. Today we will consider 3 final rules. Number 1, Part 40 provisions common to registered entities. 2, the process for review of swaps and mandatory clearing. And 3, removing of any reference to the reliance on credit ratings and commission regulations, and will be proposing alternatives to the use of credit ratings. Before even considering any final rules, I ask each rule writing team to answer a set of questions. First and foremost among those questions is whether or not the proposed final rule adheres to the agency's principle-based regulatory approach, an approach that has served the futures industry well both before and after the financial crisis. I'm concerned that the final rule regarding Part 40 is too prescriptive and does not adhere to our principle-based approach. Despite staff's efforts to soften the rule in response to comments on our original proposal, I still believe that the requirements in the final rule regarding documentation are prescriptive in nature. Additional requirements for self-certification of products may unnecessarily delay exchange innovation for little or no benefits to the CFTC. Part 40 also includes rules pertaining to rule certification for systemically important designated clearing organizations. Like both the CME and OCC, I believe that the CIDCO attempting to implement a risk-reducing change should not have to wait 60 days to change their rules. While I understand that the CFTC must consult with the Federal Reserve regarding certain matters relating to CIDCOs, such consultation should not jeopardize public interest. This portion of Part 40 seems not only slow down a CIDCO seeking to reduce systemic risk, but it may slow down our ability to approve such change as well. From early in the proposal rule phase of Dodd-Frank implementation, I've stated my concern that budget constraints and the efforts of those who would delay, weaken, or eliminate Dodd-Frank would force us to be more prescriptive than we should otherwise be in promulgating our final rules. I fear that my concerns in this instance have come to fruition in this rule. If not for our budget constraints, I would vote against this rule. As it stands, I must weigh my disdain for prescriptive, perhaps restrictive rules against the competing interest of having a rule that we can implement and enforce with an undersized and overworked staff. I also expressed concerns and questions to the chairman's office and the rule team regarding the final rule on the process for review of swaps for mandatory clearing. As has been the case throughout the process, the chairman's office and the rule team were accommodating and answering my answers, making necessary changes, and working collaboratively with my office. I will continue to give the chairman high marks for conducting an open and transparent rulemaking process. In addition to the final rules considered today, we are also considering a proposed rule on customer clearing documentation, timing of acceptance for clearing and clearing members' risk management. While I again have concerns that this rule proposal is too prescriptive, I will look to the public comment to guide my ultimate decision on whether or not to vote for this rule. I'd like to acknowledge that this week will mark the first anniversary of the Dodd-Frank Act. Over the past year, the chairman and the staff have done a tremendous job moving forward on implementing Dodd-Frank despite limited resources. As we move forward in this coming months with the bulk of the new regulations required by Dodd-Frank, I urge the chairman to place special emphasis on rules pertaining to the regulations of swap transactions, which were, in my opinion, largely responsible for the financial meltdown. With all of the Commission's new responsibilities under Dodd-Frank, this is not a time for us to make significant changes to regulations pertaining to the future industry, which functioned properly during the financial crisis. We need to focus our limited resources on regulations that will provide real safeguards to our financial services industry. I'd like to thank the staff at the CFTC for all of their hard work on these important rules. The rule writing teams have put in an incredibly long hours answering difficult and time-consuming questions from the commissioners, and I know we can quite often be difficult. I appreciate their efforts and look forward to their presentations.
Thank you, Commissioner Dunn. Commissioner Summers.
Good morning. Thank you, Mr. Chairman, and thank you to all the teams that have final rule proposals before us today. I again want to acknowledge the excellent staff work and convey my sincere appreciation to everyone who's working to get these final documents ready for Commission consideration. We are all very grateful to all of you for your commitment to this enormous challenge, and I want to reiterate what I said last week. We could not do this without all of your hard work, so thank you to all of you. This is the second Commission meeting to consider and vote on final rules, with another meeting to vote on final rules planned for August 4th. Although the final rules we have been considering thus far deal with discrete, standalone issues, complex issues dealing with market structure and business conduct standards are on the horizon. Finalizing those rules will be a difficult uphill climb, and we are beginning that difficult climb without a plan, and I believe that's a mistake. As I have said many times, formulating and sharing with the public a thoughtful plan on how the Commission will logically sequence its consideration of final rules, along with a transparent implementation plan that will allow for a reasonable phased-in approach, is critical. I believe we run the risk of unnecessarily increasing uncertainty among market participants by continuing to roll out final rules in a piecemeal fashion, one meeting at a time, without this type of plan. I support the final rules we are voting on today and have a few questions for the teams, but I'm concerned about the proposed rules. Both of the proposals were added just a couple of months ago to an already full agenda, and they are not required by Dodd-Frank. These proposals involve complicated issues that market participants have spent countless hours addressing. I question whether our proposals recognize the complexity of the issues and the amount of work that has been done on sensible, industry-driven solutions. As I have said before, I would like to see this Commission finish the job of implementing the requirements of Dodd-Frank before we turn our attention to these discretionary items. I want to thank you again, thanks the teams again, and look forward to the discussion of the rules.
Thank you, Commissioner Summers. Commissioner Amaya.
Thank you, Mr. Chairman, and thank you to the teams who have done, again, yeoman's work. I echo Commissioner Summers' sentiments that we couldn't do it without you. Today, the Commission will consider 3 final rules and 2 proposed rules. I support the final rules as they are non-controversial process rules. However, I have serious concerns with both the proposed rules as they rely on weak statutory authority, poorly articulate a necessity for either rule, and are neither justified nor required under Dodd-Frank. Today's draft rules regarding client documentation and clearing member risk standards were never previously mentioned during the months of intense rulemaking and seem to be fabricated out of whole cloth. I've grown increasingly frustrated with the rulemaking process because there appears to be no specific plan or strategy for implementing these rules. Nor do we seem to be following President Obama's direction to ensure that the federal rulemaking process be done in the most transparent, responsible, and accountable fashion. I've requested specific reforms to improve the rulemaking process, but each request has been met with silence. As we push forward, we are running out of time to make a correction. To be clear, if we fail to produce a final rule schedule and implementation plan the next time the Commission meets on August 4th, we render public input virtually irrelevant as the Commission barrels through its final rules this fall. The President has taken 3 steps earlier this year to open up our rulemaking process. The first was in his inaugural address when he challenged the American people and the government to restore trust with the American people by creating an unprecedented level of openness in government. Second, this past January, the President signed Executive Order 13563, to quote the President, to root out regulations that conflict, that are not worth the cost, or that are just plain dumb. He actually said that. Third, and last week, the President signed an Executive Order 13579 to extend the previous order to independent agencies. If the January directive wasn't clear, the new order should eliminate any doubt that agencies like the CFTC must go out of its way to ensure responsible rulemaking. We should undertake a more thorough cost-benefit analysis and make our process more accountable through increased transparency and openness, which our current process lacks. In response to the near universal cry for additional information on rule implementation, I've put forward 2 proposals to address the need for greater openness, transparency, and accountability. First, I've called that a detailed plan be produced that reveals the order, timing, and substance of the Commission's rules and specific dates as when we expect these rules to be implemented. Second, I have requested all final rules be published 7 days prior to each public meeting. Today, the public must wait days, if not weeks, for the Federal Register to publish proposed and final rules. My proposal would give the public a clear picture before the vote, not after. The Commission has responded with silence to both proposals, cementing in my mind that the current process is inadequate. The Commission is tentatively scheduled to meet on August 4th. I hope the Commission will be able to vote on a final rule order, a draft rule order and implementation plan that will have the benefit of receiving public comment. With regard to the rules before us today, Part 39 in specific, I must commend Eileen Donovan and her team for their work to establish a new process for reviewing swaps for mandatory clearing. I support this final regulation today. However, market participants have requested greater certainty as to the criteria the Commission will use to determine whether mandatory clearing is appropriate for a swap, and given our emphasis on the clearing to mandate risk, I believe moving forward on mandatory clearing without written guidance is problematic and is also arguably an abrogation of our responsibilities under Section 2H3D of the CEA amended by Dodd-Frank. Because this rule did not provide such specificity, I have drafted a letter right here that I'll be sending out to the market participants seeking their input on further defining the various thresholds and standards that the Commission should consider in determining whether a swap should be subject to mandatory clearing. I hope to receive comments during the 60 days prior to the rule, the effective date of the rule, and such comments will inform staff discussions going forward. Another concern I have with the rule is it overreaches in interpreting Section 723A3 of Dodd-Frank. It leaves open the possibility that the Commission could impose capital and margin directly on end users. This rule also permits the CFTC to impose capital and margin on bank dealers and MSP, a position with which the Office of the Comptroller probably disagrees. With regard to the 2 proposed rules, the client clearing documentation and timing of acceptance for clearing and clearing member risk management, I oppose both rulemakings. The rules before us today seem to put the cart ahead of the horse. Neither rule is specifically mandated by Dodd-Frank, nor are they well grounded in statutory authority. Further, it is unclear as to what resources the Commission will utilize to enforce these 2 optional rules. Setting aside the flawed process in the development of these rules, the first proposal regarding client clearing documentation may be attempting to solve a problem that no longer exists. The proposal alleges that the voluntary annex to a voluntary model agreement from 2 industry associations may restrict open access to clearing and harm competitive trading. I understand that more than 60 market participants on both the buy side and sell side, discussed the voluntary model agreement over a period of several months. The final agreement reflected an accommodation, even if imperfect, of their respective interests. I'm very supportive of maximizing the effectiveness of clearing. I do not want artificial barriers to clearing, such as needless credit or position limits. Based on the practices in the futures market, I am also quite certain that technology is available to ensure timely acceptance of trades. However, as the second part of this rulemaking makes evident, the industry must still resolve a number of operational issues. Therefore, there may be a certain types of documentation, a need for certain types of documentation. Ideally, buy-side, sell-side, and clearing organizations will continue their dialogue to resolve these issues. Before substituting Commission judgment for private consensus, I hope the Commission will host a public roundtable and a Commission meeting to see if the restrictions and anti-competitive effects alleged in this rulemaking actually exist, and if so, how will we resolve these issues to everyone's satisfaction. The second proposal regarding clearing member risk management fails to justify the cost in light of the benefits. First, as I mentioned, the proposal is neither mandated by Dodd-Frank or the CEA. Second, the proposal would require the Commission to ascertain whether clearing members are following certain risk management procedures. However, under another rulemaking, the Commission assigns the same responsibility to clearing organizations. Given our resource constraints, the Commission should focus on supervising clearing organizations, the main bulwark against systemic risk. The Commission should ensure that clearing organizations are fulfilling their statutory and self-regulatory responsibilities and adequately evaluating the risk management practices of their members. The Commission should not divert its resources to directly auditing clearing members, the failure of any which may not be systemic. Frankly, I would rather see the Commission dedicate resources to developing real-time trade surveillance capabilities rather than developing a redundant oversight function that will require additional resources that we currently don't possess. Mr. Chairman, I greatly appreciate the hard work of the staff and sincerely hope you will provide an answer as to whether or not the Commission will publish a rulemaking schedule and an implementation timetable that includes dates to give the market and its participants an unambiguous strategy for implementing Dodd-Frank. I hope you will also commit to publishing a draft rule when you publish the notice regarding all Commission meetings. Thank you very much.
Thank you, Commissioner Amalia. The staff will now make presentations concerning the recommendations. I think at first we're going to turn to Ananda, John, and Chris on the two proposals, if I recall. Or do I have to? I also note that Commissioner Chilton is unable to join us today, and he's becoming a grandfather, as we just chatted, so he's requested that he be permitted to vote by limited proxy for all votes taken at this meeting, a procedure that we have utilized in the past. So to that end, I request unanimous consent to permit Commissioner Chilton's limited proxy voting for all subsequent votes taken at this meeting, without objection. Now, I think I'm turning over to Ananda and his team.
John Lawton and Chris Howe are going to present the
Ananda,
proposal.
you might want to move the mic closer. I don't think
Oh,
we
I'm
can
sorry.
hear you.
John Lawton and Chris Howe are going to present the proposal for the client clearing documentation and timing of acceptance of trades and risk management for clearing members. I'm going to turn it over to John. Thank you.
Morning. Proposed rules before the Commission address customer clearing documentation and the timing of acceptance or rejection of trades for clearing. The proposals are intended to facilitate customer access to clearing and to bolster risk management through timely processing of trades. Turning first to the customer clearing documentation, the proposal consists of 3 parallel rules that would apply to FCMs, to swap dealers and major swap participants, and to DCOs. The rules would prohibit certain arrangements involving FCMs, SDs, MSPs, or DCOs that would do the following: disclose to an FCM, SD, or MSP the identity of a customer's original executing counterparty, limit the number of counterparties with whom a customer may enter into a trade, restrict the size of a position a customer may take with any individual counterparty, apart from an overall credit limit for all positions held by the customer at the FCM, impair a customer's access to execution of a trade on terms that have a reasonable relationship to the best terms available, or prevent compliance with specified timeframes for acceptance of trades into clearing. The proposals are designed to facilitate open access to clearing by customers, to remove potential barriers to competitive execution of trades for customers, and to promote risk management through timely processing. The Federal Register release would request comment on how effective the proposed rules would be in achieving these goals. Turning to the second aspect of the proposed Federal Register release, which is the timing of acceptance or rejection of trades for clearing, again, the proposal consists of 3 parallel rules that would apply to FCMs, to swap dealers and MSPs, and to DCOs. Last March, the Commission proposed rules relating to the processing and clearing of customer positions. Included in that release was proposed Rule 39.12b7 regarding timeframes for clearing. Among other things, the provision required DCOs to coordinate with designated contract markets and swap execution facilities concerning prompt and efficient processing of trading. Recognizing the key role that clearing members play in trade processing and submission of trades to clearing, today's proposal would also require DCOs to coordinate with clearing members. The proposal would also have a reciprocal rule for clearing members that are FCMs, swap dealers, or MSPs to provide reciprocal coordination with the DCOs. As previously proposed, 39.12b7 required DCOs to accept immediately upon execution all trades entered into on a DCM or a CEF. A number of DCOs and other commenters expressed concern that this could expose DCOs to unwarranted risk because they would be unable to screen trades against applicable product and credit filters. While immediate acceptance for clearing has proven successful in a number of markets with central limit order books, it might be impractical at this time for some products and markets, particularly if trades are coming in to the DCO from multiple execution venues. Accordingly, today's proposal would modify 39.12b7 to allow DCOs time to screen trades against applicable product and credit filters. Acceptance or rejections for trades in close to real time continues to be crucial both for effective risk management and for efficient operation of trading of venues. So rather than prescribing any specific length of time, the proposal would require acceptance or rejection as quickly as would be technologically feasible if fully automated systems were used. This standard would apply to DCOs and to FCMs, SDs, and MSPs that were clearing members. The proposal is intended to be a performance standard, not a prescription of a particular method of trade processing. It would allow flexibility to accommodate differences among products and markets. But as noted, the standard would tend to drive acceptance or rejection closer to real time, that is, within seconds or minutes of execution, not hours or days of execution. The proposed release requests comment on whether this standard is appropriate and how practicable it is. And that concludes the presentation on the first proposed rulemaking. Thank you.
Thank you, John, for that. I think I'll entertain a motion on the staff recommendation.
So move.
Second.
Oops. What's that? Oh, all right. I don't need that right now. So, with that, we'll take questions. And John, just if you can address, the industry has been looking at this, and certainly there's a model in the futures world as well. So how does this documentation that you're talking about compare and contrast to what's used in the futures world right now?
Typically in the futures world, I think there's bilateral agreements that a customer would have an agreement with his futures commission merchant that would go to acceptance of his trades for clearing. There's been discussion in the industry of trilateral agreements in connection with swaps, which would include potentially the counterparty to the trade in the agreement. Again, going back to the futures world, when a trade is cleared, there's no particular need for the clearing member to know who the customer's counterparty was. That it goes into a system, the trade's executed. The clearing member is going to have risk facing his customer. It's going to have risk facing the clearinghouse. It doesn't have any risk facing the counterparty. Any risk with regard to that counterparty goes to its clearing member. This rule addresses the potential for bringing the counterparty into the agreement, which could have the effect of limiting the number of counterparties with whom a customer could trade, which could potentially affect its ability to receive effective execution of its trades. It also could potentially affect the speed with which a trade is processed if a clearing member not only has to check whether a customer's trade is within its limits, overall limit that the clearing member has provided, but within some potential sublimits that it can only have a trade up to a certain size with a specified counterparty. Again, in the futures world, that sort of thing wouldn't exist. It doesn't matter who the counterparty is. There's just one overall limit that the FCM has established based on its judgment of the risk that the customer poses to it.
I support the proposed rulemaking on the customer clearing documentation and timing for acceptance. I think that it would be very helpful to get industry and public market comment, but I do think that it helps promote access to central clearing, and that's the key here, is that the asset managers and pension funds and small as well as large would be able to have access through clearing members and enter into these bilateral arrangements. I also support it because the proposal actually reproposes certain time frame provisions in the Commission's proposed rule that we did earlier this year, I think in February, in a February meeting, with regard to straight-through processing, and that there were commenters that came in on that proposal on straight-through processing, and this is an example. Sometimes we're asked, are we going to repropose? This rule actually reproposes the straight-through process, a key aspect of straight-through processing that was a number of commenters thought was too limited, and the staff thought that it would be appropriate to repropose something. But I look forward to hearing from the public and on both aspects, the reproposal of certain aspects of straight-through processing and on the client documentation. Commissioner Dunn.
Mr. Chairman, this is a very important week. On Monday, the CME announced that they were going to delist pork belly contracts. And that's an end of an era. But it does signify that there's change in this industry, and there's constant change that goes on. I see this proposal as an effort for the Commission to get its arms around some of the changes that are taking place and have better understanding. I'm not sure at this point whether I support it. However, I do support, has been my practice, of putting out proposed rules and hearing from the public. I look forward to hearing the public's input on this proposed rule.
Thank you, Commissioner Dunn. Commissioner Summers.
Thank you, Mr. Chairman. To be clear, I am supportive of the timing of acceptance for clearing changes and have no problem with that part of the rule, but I have a number of different questions with regard to the documentation part and must admit I think I'm confused. So I've gone through the actual execution agreement that we are, I guess, addressing through this proposal, and I'm under the impression from the execution agreement that it intends to address, and I'm quoting, the respective rights and obligations in the event a swap that is intended to be cleared fails to clear. That seems reasonable to me, that a clearing firm would want some sort of confirmation that a swap that is intended to be cleared is going to clear. So our proposal suggests that these arrangements potentially conflict with the concepts of open access to clearing and execution of customer transactions on DCMs or CEFs on terms that have a reasonable relationship to the best terms available. And I think where I may be confused is, do we have problems with the actual execution agreement, or do we have problems with the annexes to this execution agreement?
I think that I would say that we're requesting comment on whether there's aspects of these agreements that might run counter to the standards that are in the proposed rule, that as implemented. So we're not specifically saying there's anything wrong with anything that's been posted out there. It more goes to, as implemented, might they have the effects that we're concerned about of potentially disclosing information that doesn't need to be disclosed, or potentially limiting the access to competitive execution by by particular customers.
I think what I'm concerned about is that this actually has the opposite effect. So if we say that this kind of documentation or these kind of agreements are not appropriate for clearing members to execute with executing brokers or customers of those executing brokers, then the clearing member may be less likely to want to take on the clearing risk of smaller entities. If they are not able to have this kind of confirmation that those swaps will clear, it may actually be a barrier to smaller entities to clear than in fact what we think it could do is give those entities greater access.
One of the questions that's in the proposed release actually is, would the proposed standards have the unintended consequence of, in fact, limiting open access in any way? I mean, we're definitely open to comments in that direction, saying if someone can demonstrate that, in fact, it would have the opposite of effect of the intended effect, that the Commission would want to hear analysis that supports, if there's analysis that would support that point of view.
And then I think my last question is, if you could explain to me how that type of agreement, execution agreement, would conflict with transactions on a DCM or SEF on terms that have a reasonable relationship to the best terms available. So how would those kind of agreements actually limit you getting the best terms available on a DCM or a SEF?
If they had the effect of limiting with whom you could trade, that you could only trade with certain entities that had big, that had deep pockets, so to speak, and you could have a large limit with them. There might be smaller entities you might want to trade with, but that you wouldn't be allowed to under the agreement to execute with. That's our understanding of that. There's concern expressed out there by market participants that they might end up being limited to trading potentially with just big dealers as opposed to others who might actually in a given instance be offering a better price.
And I think this is the part where I get confused. So you'd be limited to your who you could clear with, because how would you know on a DCM who you're transacting with?
I'm not sure how often these types of agreements, they may not be applicable to DCM transactions. I think it's probably more likely to be applicable in circumstances of trading on a SEF or even purely bilateral trading where it may limit the potential counterparties.
Okay, thank you.
Could I follow up on Commissioner Summers' question caught my attention about the annex versus the agreement. This is, for members of the public, this is an industry document which is referred to in this proposal that various industry associations came together. And there's a draft, I guess, standard agreement and then an annex. So to Commissioner Summers' question, without opining, John, because I know you're being very careful, you don't want to opine on this is just a proposal, it hasn't gotten public comment, we don't even know if we'll finalize a rule in this way, but without opining on the industry documentation, would I be right to assume that it's the agreement is bilateral, or appears more bilateral, meaning between two parties, and the annex is that which is the trilateral, or appears to be between three parties, without trying to opine? Is that directionally correct?
I think that's correct.
That's correct. So to Commissioner Summers' question, which is just sort of how I understood it, again, without opining to their agreement, we're looking for, if we vote this proposal out today, we're looking for input as to the proposal, but it's possible that the annex is there may be more comments as to how the annex relates to this proposed rule than the actual agreement itself.
Yeah, I expect that that will be the case.
So I tried to answer that carefully, but it's the annex, I think, Commissioner Summers, that's the, that might run in conflict with this rule, not the agreement itself, without opining on the agreement. I think do I sort of roughly have that right?
I think that's right.
Sorry, Commissioner Amaya.
Thank you. As I noted in my statement, this is a complicated process, and I think for all of us, it's fascinating to anticipate what the market's going to look like, what the CEFs are going to look like as we go forward. We have a good understanding of what the DCM model is, and we understand what the processing requirements, and we like that. We want good competitive markets with plenty of participants without limitations. And we're beginning to develop this swap market, right? And trying to figure out how that's all going to play out. And we're trying to anticipate where we're going on that. And it's complicated. And I think that is really one of my biggest frustrations, as I noted in my statement, that this would really benefit. The industry has developed this documentation, whether it's the bilateral, the trilateral, the annex, or the voluntary agreement. They're working through these processes. I would have preferred that we had a staff roundtable to develop and understand where this is going, maybe even a commission meeting, because I find this very fascinating how all the operational challenges are going to be executed going forward. So I would have preferred more of a hearing process to develop this rule, to figure out where the industry is, and see if we can move them in a direction that is acceptable to everyone. So let's see if we can kind of continue to make that happen in this rulemaking process.
Let me just say, Commissioner Mallory, I'm supportive of as many roundtables as this hardworking and diligent staff can fit in, and if they find a time to do that in the 60-day period, or even if it's after the 60-day, I'm certainly supportive of that on this.
All right, thank you. Now, let me get to my question, because it's kind of the process issue. We developed this rule out of comment letters, concerns raised in 2 comment letters to Commission rulemakings. Other than these comment letters, in which what other communications did staff have with market participants on the FIA is the clearing derivatives execution agreement?
Staff had some conversations, meetings, I think, with, broadly speaking, representatives of the buy side, representatives of the sell side. That there were some number of meetings, and
Now, did any of these take place after the 16th, in which the agreements were completed?
I'm not sure, but I
Okay.
think not, but I'm not certain.
I understand you've reached out to them. There were a lot of comments that came in for the kind of the public. There were some concerns that were raised in April, I understand. The ISDA documentation, the FIA ISDA documentation proposing the voluntary agreement and annex was completed in June, and which included participants on both sides. Now, I understand not everyone agrees. In fact, yesterday I had a call with 2 of the largest buy-side participants, and they came down on either side of this thing. Some said it was a problem. The other side said it wasn't a problem. So I understand that not everybody agrees on every part of this. But I'd really think it's best suited if they kind of work through this with our kind of assistance, if you will. Maybe not necessarily this rulemaking. Now let me ask another question. The proposal states, quote, "No futures commission merchant providing clearing services to customers shall enter into an agreement that discloses to the futures commission merchant or any swap dealer or major swap participant the identity of a customer's original executing counterparty," end quote. Now, we know that certain CEFs may wish to operate using an RFQ on a disclosed basis. Would this rule prevent an FCM from acting as an executing broker and a clearing member on such a CEF?
No, I don't think it would. I think that, and if there's drafting clarification that would be needed, I mean, that would be something that would be appropriate for comment. But the notion would be that if one is acting as a clearing FCM, one would not need to know who the counterparty was. If one's acting as an executing FCM, by the nature of your role, you do know who the counterparty is. Or at least certainly in an RFQ situation where you're responding to a request for a quote, you're executing on behalf of your customer. That's inherent in what you're doing.
Great. Well, that's all the questions I have. I certainly look forward to the roundtable and potentially even a commission meeting on this going forward on the execution.
I thank you. I think, Mr. Staywick, if you can call the roll.
Commissioner O'Malia?
No.
Commissioner O'Malia, no. Commissioner Chilton?
I'm reading a proxy in favor of the motion to accept the staff on
Commissioner Chilton?
comment. Yeah, yes.
Commissioner Chilton, aye by proxy. Commissioner Summers?
No.
Commissioner Summers, no. Commissioner Dunn?
Aye.
Commissioner Dunn, aye. Mr. Chairman?
Aye.
Mr. Chairman, aye. Mr. Chairman, on this question, the yeas are 3, the nays are 2.
Thank you. I gather you're going to stay at the table, right?
Thank you. And next week, we'll talk about the proposed rule that addresses risk management for cleared trades by clearing participants.
Good morning again. The proposed rules before the Commission address risk management procedures at FCMs, swap dealers, and major swap participants that are clearing members. Clearing members provide the portals by which market participants gain access to clearing and are the first line of risk management. The Commission has previously proposed extensive risk management standards at the DCL level. Given the increased importance of clearing under the Dodd-Frank Act and the expected entrance of new products and new participants into the clearing system, assuring that there are effective safeguards in place at the clearing member level as well seems appropriate. Bringing swaps into clearing will increase the magnitude of the risks faced by clearing members. In many cases, it will also change the nature of the risks as well. Many types of swaps have their own unique sets of risk characteristics. This increased concentration of risk in the clearing system, combined with the changing configuration of that risk, seems to warrant additional vigilance. The proposed rules would require FCMs, SDs, and MSPs that are clearing members to do the following: establish risk-based limits in the proprietary account and in each customer account, use automated means to screen orders for compliance with risk-based limits, monitor for adherence to risk-based limits, conduct stress tests of all positions in the proprietary account and in each customer account that would pose material risk to the FCM or swap dealer or major swap participant that's a clearing member. I guess the customer part would not actually apply to swap dealers or MSPs because they would not be clearing customer positions. So that aspect would only apply to the FCMs. Evaluate its ability to meet initial margin requirements at least once per week. Evaluate its ability to meet variation margin requirements at least once per week. Evaluate its ability to liquidate in an orderly manner the positions in its accounts and estimate the costs of liquidation, and test all lines of credit. The proposal does not prescribe particular means of fulfilling these obligations. As was the case in the DCO rules, clearing members would have considerable flexibility in designing risk management procedures that would meet their needs. For example, the proposal would require stress tests to be conducted. It would not specify what inputs would be used. That would be a matter within the judgment of the risk analysts at each clearing member. And that's, again, parallel to the way the stress testing rules were written for DCOs. Over the past 2 years, Commission staff have discussed aspects of risk management programs with representatives of most clearing FCMs. The proposals before the Commission today is drawn heavily from what's been learned in those discussions. The proposed release requests comment on the extent to which clearing members have already incorporated components of the proposal into their risk management programs. The release also requests comment on the costs and the benefits of each component of the proposal. And that concludes my presentation on that one. Thanks.
With that, I'll entertain a motion to accept the staff recommendation on what I keep calling pre-trade risk filters for clearing, but I know it also has other monitoring and supervision and testing.
So move.
Second.
I support this proposal. I think it's important that all that we do in the nature of Dodd-Frank helps lower risk, and I think this does that at its core, that swap dealers, major swap participants, and futures commission merchants and the like have some risk filters when trades are being submitted to clearing, and this is really about that, about clearing, and that they be able to monitor their customers and their house accounts to make sure that they can meet the daily variation margin, and also monitor and stress test with regard to if they have to liquidate a position. I think this is part of what's come out of a lot of industry roundtables in front of this commission, and even relates to the change in the marketplace. The marketplace has become, at least in futures and securities, very electronic traded, and also has a lot of high-frequency trading. That's not yet the case in the swaps marketplace, but once swap execution facilities start to run over the next several years, one can imagine and actually predict that there'll be some electronic trading in swaps. That's what a swap execution facility will facilitate. But it's important when somebody meets at the swap execution facility that they know that the counterparty on the other side is guaranteed by a futures commission merchant, and that futures commission merchant has done something to make sure that their counterparty is not putting in a trade, whether there's a fat finger or something else put in a trade too large. I like that this says that they'd have to have policies and procedures that might include kill buttons, if I remember, kill switches, is it called?
That's right.
I think it's very important that we continue on what I consider sort of the sister to this, is the testing and supervision in the exchange world. And I see Rick Schultz here, but hopefully, that we'll have that as well, because I think clearing and trading both benefit from some of these supervision by the clearing members and the swap dealers before trades are submitted for clearing and into exchanges. So I don't really have any questions unless I got, is there anything I said there other than the opinions, but the facts, did I sort of get what this rule does?
Yes.
All right, thanks. You don't have to opine on my opinions, but Commissioner Dunn.
Thank you, Mr. Chairman. As you're aware, I've long been an advocate for increasing our entire risk management throughout how we operate within the agency, how the industry operates, how products are developed. And I think this proposal is one that I'm going to pay a lot of attention to as to what we get from the public on how the individual clearinghouses are assessing and managing the risk that they have. I don't know if there will be a best practices that may come out of this or not, but I am very, very interested in seeing what the industry as a whole has to say. And I think this is a proposal that, given what has happened in the last 3 years in financial services, it's time for us to take this hard look at risk management.
Thank you, Commissioner Dunn. Commissioner Summers.
Thank you, Mr. Chairman. I have a couple of different questions about how FCMs currently employ these kind of risk management procedures. Do we think that this is common practice for FCMs now, and how do we currently monitor that?
We currently monitor it in two ways. There's the risk surveillance group does actually go out and talk to firms, both clearing firms and actually large traders, so you learn a little bit about what the firm is doing by talking to the trader that goes through the firm, as well as by going to the firm directly and talking to them. Secondly, we monitor it because the DCOs are monitoring to some degree, or not to some, the DCOs are monitoring to some what their clearing members are doing. Again, different DCOs have different levels of programs. I think some are more rigorous than others, but in the review of a DCO, we will also learn what they've learned of what their clearing members are doing. With regard to what the firms are doing, I think I'm very much generalizing, but I think there's some firms out there that probably won't have to change anything that they do today if this rule were to go into effect. There's other firms that probably would have to make changes that they, and again, the degree of changes they might have to make would vary. I mean, some firms, it might be that there's a timing thing. They don't do stress testing as frequently as this rule might require, but they're already doing it. Other firms may not actually be doing formal stress testing, so they would have to develop some sort of program. There's a lot of, not a lot, but there are vendors out there who have stress testing products, and a number of firms are currently using those. They don't have to develop a stress testing system on their own, that there's vendors that are out there and that have their products are commonly used across a lot of firms, and again, they can be customized so that any given firm can decide what inputs they want to use, but they don't have to develop the software themselves from scratch.
Have DCOs identified problems to us that they would like to see us promulgate rules to address?
Now, DCOs I don't think have ever suggested, I mean, they've definitely identified problems, which again, depending on the DCO, they may go to the firm and say, we think you should address this directly. But no DCO to my knowledge has suggested that we propose a rule across the industry.
And would this proposal basically take that responsibility from the DCOs and put it in the commission so that it's now our responsibility to go out and monitor to whether these FCMs have these kind of procedures?
No, it'd be more parallel to the way, for example, in the financial auditing world, where you do have a DSRO that goes out and monitors in the first instance whether a firm is complying with the capital and the SEG rules, but you also have commission rules, and the commission is always available to go in itself, and both as a check on how well the DSRO is doing and a check on the FCM. In this case, I think what you would find is that different DCOs have different standards, so the effect of a rule like this might be to raise the standard at some DCOs. Again, at other DCOs, there may not be any change because effectively what they're requiring would be the equivalent of what this rule would require. There might be other people who might have to make changes to their program because perhaps the DCO rule wasn't as rigorous as, at least in some components, as what might end up in a proposal like this.
Correctly, that the DCO will be responsible, or the DSROs will be responsible for compliance with this?
I'm sorry, there actually isn't a DSRO type of program at this point on the DCO side like there is with regard, again, to the long-standing programs for capital and segregation. So it would be individual DCOs would continue to have responsibility to enforce their own rules. And then
What about for these rules?
they would not have responsibility for enforcing these rules.
And so we would have an additional, we would be responsible for this, for implementing and monitoring.
Right.
Okay, so and that would be new for us to, or this is something that the risk surveillance group already does?
It would be new in that there's a standard, a rule out there. I mean, the risk surveillance group today monitors for these sorts of things and makes recommendations, but there's not really any mechanism other than saying, and again, many times we have found that in fact the firms implement, that there have been times when we've identified something that was happening at a firm, talked to them, and they said, that's a good suggestion, we're going to do that. But there's not really any authority at this moment if they decide it's a bad suggestion or not necessary.
Okay. And my last question is it possible that in order to actually have a good risk management program, an FCM would employ things like these type of execution agreements, and that what we're doing in these two different rules is that we're saying that you can't have this even though it might be good risk management, but yet we're requiring risk management. Sorry, you don't have to answer. That's-
Thank you, Commissioner Summers. Did you have something? No.
No, I haven't thought about that, but, and I think the comment period would be great, just to address the question that Commissioner Summers asked.
I mean, I agree, that's a good
Because
question.
what we're looking at in the execution side is, the ISDA agreement is basically the FIA is purely execution. And here we're looking at it in the proposed rule that the Commission just voted on, is on the clearing side. So I don't think the proposed rule is saying don't do a good job of risk management. We just want to make sure that it concentrates on risk management and clearing as opposed to who you can execute with. I think that's the objective. The objective, as John pointed out in the previous rulemaking, was to make sure that clients had choice with respect to which FCM they could use to clear. And the worry is that, it's been expressed to us, is that if you have a tri-party, that an entity will exercise undue influence on a customer to say, if you want my affiliate to clear for you, you have to trade with me, or vice versa. If you want me to clear, you must execute swaps opposite my swaps desk. So that is what staff is concerned about, that limits the choice that customers have with who they can clear with.
Commissioner Amaya.
Thank you. This proposal addresses some of the issues raised by the direct market access and the need to monitor and mitigate risk. The Commission's Technology Advisory Committee, which I chair, has explored these same issues and offered thoughtful solutions based on independent research as well as a review of best practices and research put forward by FIA and others. As well as my understanding that the separate rulemaking team is working on rules that specifically address the risk inherent to direct market access, which are also used by HFTs, referenced by the chairman, regarding testing and supervision, as well as, I think, our DCM and CEF rulemaking teams have also kind of positioned themselves to include more specifics. What guidance did you seek from the members of the Technology Advisory Committee and internal rulemaking teams who are tasked with specifically addressing these pre- and post-trade risk management tools?
I don't think we sought any guidance from the Technology Advisory Committee. And I'm not aware of, personally not aware of any proposed rulemaking on, I know the chairman mentioned it, but I'm not sure what that objective is. But
No, I'm talking about testing and supervision.
Testing
that
and
we
supervision.
Talked about quite
Okay.
a bit.
But I think, for example, if we require people to establish credit and market-based limits, it'll probably be in line with the concerns that were expressed by the Technology Advisory Committee. The concern, and forgive me, I'm not completely...
Ananda, with all due respect, we have a document.
Right.
We have a lot of work that has gone into that. A lot of it's pre-trade risk functionality. All
Right.
of these things we've kind of addressed. The problem is when we're doing these things in an ad hoc manner, you have to answer probably and potentially and likely. And what we need to see is clear rules across all of these things so we can get clear best execution, working with Rick's group and DMO and others.
Well, I think these rules are designed to make sure that clearing members discharge their responsibility to manage risks appropriately. That's the purpose.
I don't disagree with that goal either.
Right.
The problem is the words matter, the relationships matter, and understanding how this is going to work across the market is really pretty critical. And my points in my opening statement about transparency, accountability, and responsibility, getting the rules to work well with one another are pretty important. And I have a little bit of frustration the way we're developing in an ad hoc manner, just this popcorn approach to the rulemaking. Let me, so going forward, I think there's probably a role that the Technology Advisory Committee can offer some assistance in this venue. and make sure that we've got some specific recommendations, because we did an evaluation of best practices and put forward, some very specific proposals. One of the concerns in the Technology Advisory Committee was, and now this is maybe outside your immediate thing because we were looking at a lot of this execution, but also at the FCM level, there was concern about inconsistent application of these best practices. How would this rule fix it? Would we mandate one standard across everybody, or we continue with this kind of individual approach to risk management?
I think you have to allow for individual approaches to risk management because not all clearing members have the same risk. Right? So, and that's why we're not saying, one size fits all. We're saying, I think what these are establishing baselines, but I do think that we need to leave it to the clearing member to make judgments because it depends on what kind of trades you're clearing. Some clearing firms may clear for a significant number of HFTs, and others may not. And if you're clearing for an HFT, there is a different approach, I think, to clearing to risk management. In fact, if you're clearing for an HFT, if I were the clearer, I'd be watching trades executions go in and out constantly, because if you accept the proposition that an HFT goes home flat, they may not be flat in the middle of the day. So, for example, it's entirely possible that an HFT could build up a significant position at the intraday cycle and not be able to pay, or close out the position at a big loss. And if that person is not able to pay, then the clearing FCM will have to pay. So that's why we think that it's critical for one of the proposals is that to monitor for adherence to risk-based limits intraday and overnight. And that's why we made that.
And how is that not being addressed in the DCO core principles?
Well, we think that,
especially on a case-by-case, depending
Right.
on which clearing members you're dealing with.
our approach is as follows. This is DCI's approach. Financial integrity is, you've got two key sets of players, the DCOs and the clearing members. And we believe that it is appropriate to have rules for both sets of players. Because no doubt it is not in any DCO's interest to make sure to have a failure, but we do believe that the commission also has a role, because all of these will be commission registrants. And as Commissioner Dunn pointed out, with Dodd-Frank, if you look at the structure, and I'm sure the commission is aware, there will be a tremendous amount of open interest going to DCOs, tremendous amounts of open interest going to FCN. The risk that DCOs and clearing members will increase exponentially, assuming that the clearing mandate works out and the objective of Dodd-Frank comes into fruition. So we think it's appropriate to have both sets do this.
Now, this rule applies to both swaps and futures, right?
Correct.
Okay. I recall reading in a comment letter from New Edge, I think it was in the segregation comments, that they had proposed several recommendations for increased transparency on FCM specifically. We have our Excel spreadsheet that talks about available margin, et cetera, that we post. I don't recall the form number, but New Edge proposed that we need better transparency. How does this rule address those concerns specifically?
I'm afraid I'm not too familiar with what New Edge asked for, but
They were looking at things like concentration of customers, exposure to assets, just to give customers of FCMs a better understanding of the relationship, of what their FCM exposure might be. They had several specific recommendations.
right. This doesn't go to that. That particular, I think, Commissioner, you're talking about this report that the Commission publishes, Selected Financial Information on FCMs. And what that has is, the required ANC, the excess, the required funds under segregation, and the excess. The required funds under segregation will give everybody an idea of what the exposure is, because this is.
But
the
does it
amounts
give
of
you
money.
the level of exposure where all of this is CDS, for example?
Right.
Would people know that from that report?
No, they would not know that.
Or they wouldn't know whether there's a single large customer?
Right. The worry with that is we also have Section 8 of the
Of
Act.
course we do.
So the question is, how do we find a balance between providing information, public information about our registrants to the public and crossing that line?
Maybe you could go back and look at the New Edge letter
Yeah.
and see if
Yeah.
any of those comments are relevant to this rulemaking. Commissioner Summers raised a question, since we do charge DCOs with this responsibility, what happens if there's a conflict between a DCO saying, we propose this level of recommendation, and the CFTC coming in and say, no, we want something different? Now with this new authority that we have, as opposed to working exclusively with the DCO, or not necessarily exclusively, but using that as our main, addressing that through the core principles in the DCO rulemaking. Now we have kind of two different venues. How do we resolve conflicts?
In a DCO rule and the Commission's rule?
Or, DCOs surveilling for their customers, we come in with this new authority and say, well, we have a different opinion.
Yeah.
What happens when there's a conflict?
Well, I think first of all we'll try and see if we can resolve the conflict and try and find out why there is a conflict. But at the end of the day, I believe the Commission rules trump the DCO rules.
Well, of course they do, but why couldn't we do that through the DCO is kind of my point.
Well, I think. Well, John, did you want to say that?
I was going to say that if we, over time, developed an interpretation of what the requirements are under this, I think we would then go into the DCO core principles and say we would require the rule which requires DCOs to have standards to come up to that. So I think that's what I would expect that we would recommend. You agree?
One final question. How many people will this new responsibility require to surveil it and manage it?
If I were to take a very educated guess, I'm going to say 20 people to go to the to the clearing FCN.
So that we don't have this in our budget? Because this seems new to me, frankly. And in the 12 budget, and certainly in the 11 budget wasn't there, but in the 12 budget, I don't think it's this responsibility is specified. So that's why I'm asking how many people.
I think we had mentioned it in the 12 budget because I think in the risk surveillance budget we'd always talked about going to the firms, not just to the DCOs, but going to firms and large traders to make sure that they're conducting appropriate risk management.
So how many new FTs will we have in the DCO surveillance responsibility to kind of surveil core principles?
I don't know that number offhand. I can.
Fair enough. Thank you.
Thank you, Commissioner Amalia. Mr. Staywick?
Commissioner O'Malia?
Nope.
Commissioner O'Malia, no. Commissioner Chilton?
Aye by proxy.
Commissioner Chilton, aye by proxy. Commissioner Summers?
No.
Commissioner Summers, no. Commissioner Dunn?
Aye.
Commissioner Dunn, aye. Mr. Chairman?
Aye.
Mr. Chairman, aye. Mr. Chairman, on this question, the yeas are 3, the nays are 2.
Thank you, Mr. Staywick. Thank you, John and Nanda and Chris. And with that, I think that the majority, having voted on both of those, they'll be sent to the Federal Register and posted on our website post haste. You'll be able to post them actually today. I'm for the same transparency Commissioner May is for, that we should post these the day we
This rule, oh, yeah.
the day. Now he has other suggestions maybe
Oh.
earlier, but I see no reason why we don't do it the same day.
I think
and we
that's
should
been the
put that
practice.
out.
The teams
And
have
I
sent
know
it
we have
to-
a
yeah.
difference on this
Okay.
other piece, but the same day, let's put it up on our
Yeah,
website.
absolutely.
Eileen, are you going to come up next? Do you have the seat? At this time, I'd like to welcome Eileen Donovan, John Lawton, and Ananda Radhakrishnan, all from the Division of Clearing and Intermediary Oversight. Eileen has been the team lead on this important role, and so I hand it over to, I suspect Eileen's probably going to take the lead here. Is that right? Or I'm not trying to pick amongst you. No. All right, thanks.
Good morning. The final rule before the commission
You might
is-
want to bring the mic a little
Okay,
closer to
sorry.
you.
Good morning. The final rule before the commission establishes a process for the review of swaps for mandatory clearing. This rule has 4 parts. The first part implements the provision of Section 745B of Dodd-Frank that requires the commission to prescribe criteria, conditions, or rules under which the commission will determine the initial eligibility or the continuing qualification of a DCO to clear swaps. Under the rule, a DCO would be presumed eligible to accept for clearing any swap that is within a group, category, type, or class of swaps that the DCO already clears. A DCO that plans to accept for clearing any swap that is not within a group, category, type, or class that the DCO already clears would be required to request a determination by the Commission of its eligibility to clear the swap. To receive such a determination, a DCO would have to submit to the Commission a written request that addresses its ability to maintain compliance with the DCO core principles if it accepts the swap for clearing, particularly the sufficiency of its financial resources and its ability to manage the risks associated with clearing the swap, especially if the Commission determines that the swap is required to be cleared. The second part of the rule concerns the submission of swaps to the Commission by a DCO. Section 723A3 of Dodd-Frank provides that it shall be unlawful for any person to engage in a swap unless that person submits such swap for clearing to a DCO that is registered under the CEA or a DCO that is exempt from registration under the CEA if the swap is required to be cleared. Section 723A3 also requires the DCO to submit to the Commission each swap or any group, category, type, or class of swaps that it plans to accept for clearing so that the Commission may review such submission and determine whether the swap or swaps described in the submission are required to be cleared. The rule requires a DCO submitting swaps to the Commission to provide certain information to assist the Commission in its review, including a statement that addresses the 5 factors that the Dodd-Frank Act requires the Commission to take into account when reviewing a swap submission. Those 5 factors include the existence of significant outstanding notional exposures, trading liquidity, and adequate pricing data, the availability of rule framework capacity, operational expertise and resources, and credit support infrastructure, the effect on the mitigation of systemic risk, the effect on competition, and the existence of reasonable legal certainty in the event of the insolvency of the relevant DCO or one or more of its clearing members. The rule would also require the DCO to provide a statement of its eligibility to clear the swap, product, participant, and pricing information, applicable rules, manuals, policies, or procedures, and a description of the manner in which it has notified its members of the submission. The Commission must receive the submission by the open of business on the business day preceding the DCO's acceptance of the swap for clearing. The Commission would post the submission for a 30-day public comment period and make its determination no later than 90 days after receiving the submission. The third part of the rule concerns Commission-initiated review of swaps. The Dodd-Frank Act requires the Commission on an ongoing basis to review swaps that have not been accepted for clearing by a DCO to make a determination as to whether the swap should be required to be cleared. Under the rule, if no DCO has accepted for clearing swaps that the Commission finds would otherwise be subject to a clearing requirement, the Commission must investigate the relevant facts and circumstances and, within 30 days of the completion of its investigation, issue a public report containing the results of the investigation. The Commission would take such actions as it determines to be necessary and in the public interest, which may include establishing margin or capital requirements for parties to the swaps. And finally, the last part of the rule concerns the stay of a clearing requirement. After making a determination that a swap or group, category, type, or class of swaps is required to be cleared, the Commission, on application of a counterparty to a swap or on its own initiative, may stay the clearing requirement until it completes a review of the terms of the swap and the clearing arrangement. If the Commission decides to issue a stay, it would have 90 days to complete its review of the clearing of the swap. Upon completion of the review, the Commission could determine, subject to any terms and conditions as the Commission determines to be appropriate, that the swap must be cleared or that the clearing requirement will no longer apply. And thank you. That's the end of my presentation.
Thank you, Eileen. I support the final rulemaking to establish a process for review and designation of swaps for mandatory clearing. One of the primary goals of the Dodd-Frank Act was to lower risk through moving the standardized swaps to central clearing. Not all swaps, many swaps, customized swaps, bilateral. Many end users will be able to hedge that which they want by not using a clearinghouse. There won't even be a clearing mandate for non-financial end users, but the financial end users would still be able to do their customized swaps. But Congress said there should be a process about this mandate, and I think this final rule is consistent with the congressional requirement that the clearinghouses themselves, who are eligible to clear swaps, then submit swaps to us and put it out to public comment based on 5 statutory provisions. I think that we've taken into consideration numerous comments. I think it was only about 20 comments or 18 or something, if I remember the count. 20, was it?
26.
26, there you go. But what I took away from the commenters was trying to lessen some of the burdens of these regulatory filings, and I think I want to compliment Eileen and the others on this team for taking into consideration those comments. I don't have any questions, but I'm supposed to ask for a motion. I'm sorry, I forgot that part. That's important. A motion on the staff recommendation on a final rule on mandatory clearing process.
So moved.
Second.
So now I state that I support it, but any questions from Commissioner Dunn?
Thank you. As I stated earlier, I've asked a number of questions to the division and the rulemaking team. And on this, I had asked how many folks it would take to implement that. I believe the answer was for DCIO approximately 20. Is that correct?
Commissioner, in response to your questions, we had said an additional 5 FTEs to work on the mandate determinations. Based on the President's request, 2012, the President in the budget requested 70 FTE for the clearing policy and risk surveillance sub-program, and we had planned to allocate 5 for the mandate determinations.
So it'd be 5 on this. Is this in addition to the 20 that you talked about on the other proposed rule?
Yes.
How do you intend to implement this if we don't get increased budget?
I think the issue will have to be a prioritization of work. So what DCIO will recommend to the Commission is that we do the things that we're required to do, and then with respect to those that we may not be required to do, they may have to take a back seat until we finish the things that we're required to do. Because these mandate determinations have to be made within a 90-day period.
Thank you.
Thank you, Commissioner Dunn. I just, Ananda, this 20, I'm sorry, because I was conferring with Sarah. There's a risk surveillance group in Chicago right now.
Correct.
Is it not, right? So maybe I'm not following it, but on the earlier proposal, and it was just a proposal, but doesn't the risk surveillance group in Chicago already, I mean, of course, they have other duties, but that group would have to take on this, you know, if we were to finalize the Futures
Correct.
Commission. So it'd be,
That group, yeah.
it's that group.
Right.
So were you saying, I don't remember the size of the risk surveillance group in Chicago, but it's 20 including.
Right now we have 22.
Right now they're 22, and so that would have to grow.
Yeah.
Okay.
Yeah.
Commissioner Summers.
Thank you. I have a couple of different questions about the process that I think I'd like to clarify, and especially for those people who were very concerned about this process through the comment period. So the process for reviewing pre-enactment swaps that are currently being cleared, those swaps were deemed submitted to us on July 21st, 2010, but we had agreements from all of the DCOs to extend that 90-day period, the way I understand it, for making that determination. Is that correct?
That's correct.
So we're currently operating under that extension from DCOs that currently clear swaps.
Correct.
So does that extension of time also apply to swaps that they started clearing post-enactment? So it's not just pre-enactment, it's also post-enactment swaps?
No, because by law, I think by the statute, the deemed submission, and correct me if I'm wrong, was the deemed submission was in relation to pre-enactment. Swaps already
Only.
being cleared pre-enactment.
So only pre-enactment swaps. Anything that is currently being cleared, but being cleared post-enactment, a DCO would have to formally submit to us. They're not deemed submitted.
Correct.
The effective date of this rule, would that affect the clock on the extension, or does the clock start running again another 90 days after the effective date of this rule?
I think the arrangement we had with the DCOs was that it wouldn't start until 90 days after the effective date of this rule.
So 90 days after the effective date of this rule, if we're not prepared to make a determination, we'd ask for another extension? Okay. And is it possible that we would decide at the conclusion of that 90 days that we're not prepared, or that the answer is no? These swaps are not yet mandated for clearing. We need another 60 days. We need another 180 days in order to make a mandatory decision, because there may, for a number of different reasons.
That is possible. That is possible.
But
Because,
we
you know,
have
we've-
the ability to do that.
Yeah, because we have to go through the 5 factors, and the commission will have to be satisfied that the 5 factors are satisfied.
And
Amen.
how will what's the process for reviewing those decisions? So we consider the 5 factors,
Yeah.
but how often do we consider those 5 factors, and what's the review of the decision? If you can contemplate that we have the ability to make a decision that no, these swaps that are currently being cleared are not mandated to be cleared, how do we go back and review that decision?
I think the commission can at any time of its own volition go back and examine whether any class category type of swap has to be cleared. So I think the commission has the flexibility to do that. So I guess if
Why
you-
would we initiate that? I mean, I guess from your perspective, what would change? What would you be looking for?
probably new information, because one of the factors is, let me get to the factors. Outstanding notional amount, liquidity, and so on. So, significant outstanding notional exposures, trading liquidity, and adequate pricing data. So if it were to transpire that the commission believes that that factor is not met because of a dearth of information, all the information we have is from DCOs, but the way I look at it, a significant outstanding notional exposure doesn't just relate to cleared swaps, because there may be other swaps which are uncleared. Staff will probably go to other sources, by the BI, publicly available sources. But it could well be that we don't have enough information. The commission is not satisfied. But I think one of the things that really would help us is SDRs. If a lot of stuff is reported to SDRs, then the commission has an avenue to get this information. So it could be that once SDRs are registered and they start operating, the commission could be in possession of information that will allow it to make a determination.
So getting more accurate information
Yes.
would be helpful.
Yes, absolutely.
The next set of questions I have are on eligibility determinations. So the rules provide that a DCO is presumed eligible to accept for clearing any swap that is within a group, category, type, or class of swaps that a DCO is already clearing, but that this presumption is subject to commission review. If a DCO wishes to accept a new type of swap for clearing, it must ask the commission for an eligibility determination. So do we have a time period in which we need to make that determination?
We don't have a set time period.
And will we be making those eligibility determinations on DCOs that currently clear swaps?
Eileen, why don't you just
Sorry,
answer?
because they would be presumed eligible to clear the swaps that they're already clearing. It's
Okay.
only if, like, for instance, they're clearing interest rate swaps and suddenly want to do CDS that we may have to revisit their
That
eligibility.
would initiate another,
Right.
a different asset class would
Right.
initiate another determination.
Right.
Okay. And how will we make those determinations? Will it be a commission determination by commission order? How will we do that? And will we seek comment?
I would envision it to be a commission action. And I think it makes sense to get public comment on it.
Another area that I have some concern about, but I do believe we've addressed in the final rule, is with regard to making a determination that a swap must be cleared if no DCO has accepted it for clearing. So if you could just walk through how you would anticipate that process working. Why would we make that kind of determination if no DCO has accepted a swap?
Well, that's a good question. The response is that the commission has the legal responsibility to do so. So some people have argued that it doesn't make any sense to make a determination if no DCO is going to clear it because it may be an empty determination. But I guess what I can't predict is why a DCO may not want to clear a swap. It may be that the commission gets information that a certain category of swaps, it's a no-brainer that has to be cleared, but because of what's happening structurally at DCOs, nobody wants to clear it. It could be, I don't know.
But because the statute prohibits us from forcing a DCO to clear something,
Right.
I mean, what do you think we would do? Have a round table and talk to all DCOs about why nobody's clearing?
I think that's a fair question. For example, before Dodd-Frank, we had conversations with DCOs, and this was before the language was finalized. And I asked a question as to whether there were any classes of standardized swaps that somebody will not clear. And this doesn't apply to us because everybody said equity swaps, that they're standardized, but nobody wants to clear them because they cannot model the risk. Now, to me, that's a very critical piece of information. That if somebody doesn't know how to model the risk, either doesn't know how to model the risk or knows how to model the risk, and it'll be so expensive that nobody will want to clear it, or nobody wants to take the risk. So I guess what I'm saying is we just don't know what people will tell us. And so that's why I think that, and I guess that's why Congress gave us that responsibility for two reasons. I'm guessing one, because they're worried that people will collude and not clear something. So it would stand to reason that logically, if you would make the first determinations with respect to things that people are already clearing. But I guess my answer is I just don't know. So
Thank you.
Commissioner Malia, but just before, Ananda, I think that if I recall, and Dan Berkovitz is here, I mean, Congress included this provision that we could initiate a review. And we say clearly, I think it was good that we said this in the preamble, that the commission anticipates that initially mandatory clearing determinations would only involve swaps that are either already being cleared or that a DCO submits to clearing. I
Right.
mean, that we're going to first let the clearinghouses come
Right.
to us.
Right.
And they're already clearing. I mean, in the
Right.
interest rate swap world, the
Credit
largest
rates.
clearinghouse has close to $300 trillion notional amount of interest rate swaps in it. And we've been regulating them for 10 years along with the FSA.
Right.
Um,
Broad-based index CDS,
Broad-based index CDS are being cleared.
energy.
Energy, and actually it has lowered the risk in the energy market significantly these last 8 or 10 years post the Enron. So in the energy and the interest rate and the index space.
And some agricultural as well, Mr. Chairman.
So, I mean, I think it's important that the commission has actually said here what we've said, that we anticipate initial mandatory clearing determinations would involve the swaps that are already being cleared or a clearinghouse wants to clear.
Yep.
And then we're going to, I mean, this is going to take a while. I mean, but the Congress still has this you might consider it a backup authority on that we could initiate something from time to time. In the future, we might, but I think initially this is what we've said. And if we all vote for it, I think that's a good statement of where we are. But, I mean, Dan, is there anything Commissioner May?
Well, Mr. Chairman, I think you've highlighted an important point. In futures markets, it's voluntary. In this, we're mandating it. There's no statute that says you have to clear future space. This, we are mandating it. This is a different breed of cat, and we're going into this not knowing exactly how these things trade, what features they're going to be, how they're going to be priced, what type of liquidity, et cetera. Feature that I've asked for in terms of guidance. I mean, what are the criteria that we're going to use going forward? So let me. So I think it's a valid point, but this is a bigger challenge than simply saying it's a one-size-fits-all futures model, because it's not. And we have our.
I don't think I said that.
No, you didn't.
Okay.
But I'm just agreeing with you, actually.
All right.
All right. Well, in some of the comment letters we received, they'd asked, market participants and had asked for more transparency and clarity on some of the substance. And specifically, they had asked for, what are the criteria the commission will be using going forward in determining what's clearable, et cetera. How do you reconcile one little I moving forward on mandatory clearing without guidance and in Section 2H3D? The section states, quote, "The Commission shall adopt rules for reviewing a derivatives clearing organization's clearing of a swap or a group, category, type, or class of swaps that it has accepted for clearing." There's some broad categories that the statute gave us, but it gives no balance as to how we're going to determine which are more relevant, how we're going to, what's important, what standards are going to be within those categories. And I'm just sensitive to the market that they've asked for some more information.
So, I'm sorry, are you referring to 2H3E?
D. 2H3D.
Okay. 2H3D, I'm sorry, maybe I'm misunderstanding something. I think that's what we're trying to do, which is to comply with 2H3D.
Eileen, do
I
you
think
want
it's,
I may be missing something.
Eileen?
Right, I mean, that was the basis for this rulemaking, yes.
yeah, but people have asked for additional guidance, and we haven't been specific. I mean, we've had this discussion.
Guidance with respect to the factors?
Yeah.
Okay. So, I don't know whether this is the place for guidance. To me, one approach I would take is Congress has given us the factors to consider. I'm not sure what additional guidance we could give, because the way I look at it, the Commission will have to seek comment as to whether, let's say, interest rate swaps have to be cleared. And I would imagine that the Commission will be asking questions with respect to the factors. So are you suggesting that, or are the commenters suggesting that the Commission have a view
Well, the commenters did ask about different weighting of the various factors, the importance of the factors, what the minimum standards of the factors were.
Right.
So they did ask for several specific areas, which we did not provide specificity on.
Well,
And so one of the concerns I have is
Yeah.
if we're going to move forward on a case-by-case basis,
I think we have to.
So
I
if
think we have to
do,
move on a case-by-case basis because the asset classes are different.
asset classes are different, but is that the only factor? Because if we move forward on a case-by-case basis, and maybe Dan wants to weigh in on this, doesn't that really open us up to potential legal challenges such as those relating to arbitrary and capricious action?
Well, Dan can opine on this, but with respect to the comment that maybe some of the factors should have more weight, I don't know whether the statute allows us to do that because Congress gave us 5 factors.
Yeah,
And I
but-
think we have to consider the 5 factors.
Well, no doubt.
Right.
But on a case-by-case basis, then we seem to be ignoring 2H3D, which says a rule. Because if we're going to implement this separately, when we have an obligation, the Congress told us to implement a single rule, I think we're kind of caught up in this
Dan, you want to
debate here.
address this?
Generally, the agency has the flexibility, as Anand has been talking about, to do, in a situation like this, to either do a rulemaking with additional guidance
Which is what 3D specifically says.
or it could, as Anand has explained, do it on a case-by-case basis. You say we will consider the statutory factors, weigh the statutory factors, put out its determination for public comment, get the public comment, and then make a determination based upon the record. As you've noted, its determinations would have to be rational, could not be arbitrary and capricious, and to a certain extent, if the agency chooses to proceed on a case-by-case basis, it would be developing essentially case law as to how it's applying the factors, and that would become the body that would guide the future determination. So if you made a certain determination with respect to one particular type of swap and how the factors were weighted, that would guide the agency in its future determination. So you could do it either through a rule or through a case-by-case determination with a sufficient explanation of the rational basis for that.
All right. Well, I assume this has the votes. I'm going to vote for it, but I am sensitive to the questions asked by commenters that they want a little more granularity on what the commission's priorities are in determining what a swap will be. I'll send a letter out, and I hope in the 60 days it would get that the market does provide meaningful comment as to what relevant factors they think are in the market, and then we adjust that and maybe reflect on that as we develop this case-by-case evaluation. All right, my second question are targeted at the interconnections between the rulemakings, this rulemaking and other rulemakings. What definition of swap is this rulemaking using?
Dan, you want to go?
The rulemaking does not rely on a specific definition, but clearing agencies or clearing organizations would be able to submit instruments that they would consider swaps, and the commission could proceed to evaluate those prior to the completion of the definitional rulemaking.
So if we have a clearing requirement effective before the definition of swap, that won't matter?
Well, this doesn't impose the clearing requirement itself.
But if we do have a clearing requirement, and we have swaps that have to be cleared, the definition of swap is somewhat.
Commissioner O'Malley, I'll help you out. I'm in the same place you are on this. I think this is a process rule, an important process rule, where clearinghouses might come to us in 2 to 3 months and start that 90-day clock. But I think, like you and maybe other commissioners, I think any mandate that has, a legal mandate should come after we finish that swap. We're only further defining a swap. I think everybody knows what a 2-year interest rate swap is, but the further defining the swap, I think the comment period closes July 22nd. It's emblazoned in me. And talked to Chairman Shapiro yet again yesterday at the tail end of the Financial Stability Oversight Council and the importance of, once that closes, to get our mutual staff summarizing comments and finalizing that, as well as finalizing the entity definition thing.
Right.
I think what the five of us could compete on our enthusiasm in finalizing those joint rules, but I'm right with you on
Good, thank you.
finalizing those.
Mr.
I'm
Chairman,
not
if-
putting out a schedule for it because I just don't know. I'd love to say we're going to finalize it in September, but I think it's going to take longer. I think it's going to be, into the fall for the entity definition one, and on the product definition one, the comment period hasn't closed yet. So I'm sorry, Commissioner Dunn.
I was going to ask for you to give us an estimate, but I guess you just did.
No, push him on it.
My best estimate is that on the entity definition, it's post-Labor Day for sure, and I don't see it happening in September because we and the SEC both like to get to what's called a pens down version, and get commissioner feedback on that pens down version promptly. But it's possible that we'll get that pens down version on the entity definition in August and try to schedule it for the September 22nd meeting, but I think it's more likely in October. And then on the product definition rule, since the comment period hasn't even closed yet, it's probably going to take us past Labor Day to summarize the comments, get them to 10 commissioners instead of 5, of course, in that case, and probably talking about closer to that Thanksgiving period. But I don't want to, we're not going to bring a document to you all and to a vote unless it's really gotten the feedback from all of you and obviously the SEC commissioners as well. It's one of the challenges on doing a precise schedule with precise dates. It sort of flies in conflict of getting it right and getting the balance. And I think that come November, we may well be most likely taking up the exemptive order again, given those facts and circumstances, and looking at whatever other relief we need, because I don't want to try to manage against a clock. It's more important to get it balanced and get it right and get all the inputs from staff and commissioners.
Let me go to my next question. Do you believe that the Commission has the authority under CEA Section 2H4B 3i to impose capital and margin requirements on bank swap dealers and bank major swap participants?
I think the document says that we will act, the Commission will act in accordance with other regulations.
Here, I can read it for you if you.
Yeah.
Quote, footnote 10 states, the Commission would consult with the prudential regulators before taking action under Regulation 39.5C3 3i, which would include margin capital.
What's the document? Well, because I think we are saying, Commission notes that with page 21, Commission notes that with respect to swap dealers and major swap participants, it will not impose margin or capital requirements under 39.5C3 that differ from final Commission regulations on margin or capital for uncleared swaps. And then the document says, further, the Commission does not foresee that it would take action under 39.5C3.3 to impose margin or capital requirements on any swap counterparty permitted under final Commission regulations to exercise the end-user exception to mandatory clearing.
Dan, do you believe that we have the authority, yes or no, on that? To set it on bank dealers?
I think this footnote was, and this addressing here was to address the conflict, the difference, to reconcile the various statutory provisions. And so in attempting to do that, it's that obviously we have the the concerns on, as you've talked about, so we have to reconcile these various provisions, and that's what we would do.
Let me turn to the end user exemption. We have language in the preamble that says the commission does not foresee that it would take action under the final commission regulations to exercise end user exemption to impose. Essentially, the commission does not foresee applying capital margin on end users. I'm a little concerned because I thought Congress was pretty clear about this, and certainly the Dodd-Lincoln letter to follow that was pretty clear about this. Does not foresee kind of has some wiggle in it. Why did we include those words?
I think it's because of, as Dan pointed out, you got different statutory provisions, right? Because the statutory provision that says, Commission can take such actions as the Commission determines to be necessary and in the public interest, which may include requiring the retaining of adequate margin of capital by parties to the swap, group, category, type, or class of swaps.
So does that
That's
trump
a
the end
statutory
user
provision.
exemption?
Commissioner Amalia, maybe the word came from me. I was trying to be respectful of the process that we hadn't finalized the rule. That's all. I don't foresee that we're going to do it, but we have a proposal outstanding, and that on the margin issue, the margin proposal we put out is clear that we're not imposing any margin on dealers don't have to collect margin from end users, but it's a proposal, so it may have just been me, just that it hasn't been finalized.
Well,
I
think
I
going
would
forward,
hope subject to the comments, but not trying to envision what the final action would be, that it would be consistent with what was proposed. That was.
All right. Well, I just hope that on
I don't
that
think
one,
there's any difference between you and me on the end user margin issue.
then we really shouldn't put it in the, insert uncertainty into the language. But I take you at your word, and hopefully the comments will reflect, and hopefully the language in the final form will be much more certain for the end users on that one. That's all I have. Thank you very much, Eileen. Great job.
Mr. Staywick?
Commissioner O'Malia?
Yes.
Commissioner O'Malia, aye. Commissioner Chilton?
Aye by proxy.
Commissioner Chilton, aye by proxy. Commissioner Summers?
Aye.
Commissioner Summers, aye. Commissioner Dunn?
Aye.
Commissioner Dunn, aye. Mr. Chairman?
Aye.
Mr. Chairman, aye. Mr. Chairman, on this question, the yeas are 5, the nays are 0.
Thank you, Mr. Staywick. Thank you, Eileen, John, and Ananda. Dan, for your cameo. I gather at this time I'd like to call Bella Rosenberg and a team up, Joe, Tom, Riva, and Rick from the Division of Market Oversight, and Phyllis from the Division of Clearing and Intermediary Oversight, to present the staff's recommendations regarding the final rule on certain provisions that are common to registered entities, or what often in the industry is referred to as Part 40. Presuming Bella is taking the lead here.
Yes.
Thank
Good
you.
morning, Mr. Chairman and Commissioners. Today, staff is recommending that the Commission approve the final rulemaking to implement rule certification and approval procedures for existing registered entities such as designated contract markets and derivatives clearing organizations, and for new registered entities such as swap execution facilities and swap data repositories. The rulemaking also prohibits event contracts based on certain excluded commodities, establishes special procedures for certain rule changes proposed by systemically important derivatives clearing organizations, SITCOs, and provides for staying of review periods for certain novel derivative products pending the resolution of jurisdictional determination. Following the publication of the proposed rulemaking on November 2nd, 2010, the Commission received 10 comment letters. Staff carefully reviewed the comments and made a number of changes to address commenters' concerns. The final regulations establish a new timeline mandated by Dodd-Frank for self-certified submission of new rules and rule amendments. A new rule or rule amendment will become effective 10 business days after the certified rule or rule amendment is received by the Commission. The Commission may stay the initial review period for additional 90 days if the submission includes a novel or complex issues or is certified with inadequate explanation or is potentially inconsistent with the Commodity Exchange Act. The Commission must provide a 30-day public comment period within the 90-day review period. The new rule or rule amendment will become effective 90 days after the certification is stayed, unless the Commission objects to the certification. Notably, the Dodd-Frank Act mandates the above-mentioned timeline for self-certified rules and rule amendments, but not for self-certified new products. The timeline for filing products for self-certification remains unchanged. That is, the Commission must receive a submission at its headquarters by the open of business on the business day preceding the product's listing. Also, the final regulations have been modified to address certain concerns raised by the comment letters. Specifically, with respect to the product and rule certification, as requested by a number of commenters, the final regulation eliminates the requirement that a registered entity must include with its submission documents relied upon in determining that a new product or a new rule or rule amendment complies with the Commodity Exchange Act. To balance the staff need for information to carry out reviews while conserving staff resources, and also to alleviate the commenters' perceived burdens of complying with the documentation requirement, the final regulations only require the submission of a concise explanation and analysis of a product or a rule or rule amendment. And in case of a new product submission, such concise explanation and analysis must provide a simple reference to data sources. Furthermore, in consideration of a number of comments, the final regulations do not adopt the previously proposed provision requiring a registered entity to certify that it has rights to use or reference a third-party prices. Also, to streamline the product certification process for a significant number of swap contracts, the final regulation permits CEFs and DCMs to certify within a single submission one or more swaps without submitting each swap and its supporting information to the Commission, if the class of swaps meets certain conditions that are specified in the regulations. Moreover, to further streamline the new product submission process, the regulation permits DCOs to submit products accepted for clearing only under the forthcoming provision of 39.5 and not under Part 40. With respect to certification procedures for submission of rules by CITCOs, in accordance with Section 806 the Dodd-Frank Act, the regulations require a CITCO to provide the Commission with a 60-day advance notice of any proposed change to its rules or procedures that could materially affect the nature or level of risk presented by the CITCO. The regulation allows the CITCO to implement the proposed rule change if the review period lapses without Commission action. The rule would allow the Commission during the 60-day review period to extend the review period for additional 60 days if the proposed change raises novel or complex issues. Turning to the provision relating to event contracts, essentially the final rule remains unchanged from the proposed rulemaking. The final rule prohibits the listing, trading, or clearing of certain products that are based on excluded commodities that involve terrorism, assassination, wargaming, or an activity that is unlawful under any state or federal law. These activities are specifically enumerated in the statute. In addition, the rule provides that the listing, trading, or clearing of products involving activities that are similar to the activities that are prohibited by the statute and that Commission determines to be contrary to the public interest would be prohibited and would be enumerated in a future rulemaking. Furthermore, if the Commission determines that a submitted product involves or may involve one of the prohibited activities, the Commission will request that the registered entity suspend the listing or trading of this contract and will conduct a 90-day review to determine whether the product violates the prohibitions on certain event contracts. Upon completion of its review, the Commission will issue a determination order. And finally, the rules authorize the Commission to state the product certification or approval review period for novel derivative products that have elements of both a security and a commodity futures and options contract, pending the issues of a final determination order as to whether the Commission or the SEC has jurisdiction over the product. That concludes my remarks. I would
Thank
be happy
you.
to take any questions.
Thank you, Bella. The chair will now entertain a motion to accept the staff recommendation on the final rule related to Part 40.
So move.
Second.
Okay. Thank you. I support the final rulemaking to establish a process for certification and approval of new rules and rule amendments for various registered entities, designated contract markets, and the clearinghouses, and the new registrants, the CEFs, and data repositories. The Dodd-Frank Act established enhanced review and certification of new rule and amendments, and I think the final regulations here provide the procedural guidance for the various entities. I appreciate Bella and the team's work on the rule itself and taking the commenters and trying to lower the burden. In some instances, though, it was Congress that really did change something, and I would just note two areas because I know Commissioner Dunn and I have had a lot of conversations about this. One is with relate to event contracts, those contracts Bella mentioned on anti-terrorism and the like, and even gaming, I guess, is in the
Yes, it's
statute,
in the
right?
statute.
So the designated contract markets and swap execution facilities will be able to move forward on products with great certainty. I don't envision, nor does anyone, I think, envision that we're back in the 1980s and 90s of product review, but Congress had a specific provision that not supposed to do contracts, event contracts like these. So I think the role is consistent with what Congress laid out, but that is something that I know we've chatted a lot about. And then secondly, on Title VIII, if a clearinghouse is deemed systemically important by the Financial Stability Oversight Council, and we're their primary regulator here at the CFTC, we have to provide more time. I'm hoping that we can not run 60 days to figure out whether something is risk reducing or risk enhancing, but apparently Congress wanted that additional time so that the Federal Reserve and other regulators could take a look at it as well.
Yes. Mm-hmm.
So, but I support the rule because I think it does what Congress said to do, and it addresses industry comments. Commissioner Dunn?
Thank you, Mr. Chairman. I have no questions on this. I commented extensively in my opening statement on this particular proposal. I do hope that future commissions do not see this as the instrument in which they can begin going through product review on every issue that comes forward from the exchanges. I have a lot of reservations on this. As you point out, it is part of the statute, and we have to follow the statute. I just hope that futures commissions show a good amount of restraint as they implement this rule.
I share your view about product review. If I recall, the history of this is it was just about when movie futures were being debated, and I think some of these provisions on the event contracts and anti-gaming were topical to certain senators and members of the House of Representatives at the time. But thank you. Commissioner Summers.
Thank you. I have a couple of different questions with regard to the CIDCO parts of the rulemaking for Phyllis. In the part of the rulemaking that's specific to the SIDCOs. There was one part 40.10 with regard to DCOs and their supervisory agency. And it had been suggested to us that we clarify that language with regard to SIDCOs and who their supervisory agency would be. And in the final rule before us today, it says that we intend to act by revising the definition of systemically important derivatives clearing organization in a future final rulemaking to clarify that a SIDCO is a financial market utility that has been designated by the FSOC to be systemically important and for which the Commission acts as the supervisory agency. Can you tell us which future final rulemaking this will be part of?
Yes. As you may recall, there have been a series of rulemakings to implement DCO core principles. And within those rulemakings, we have proposed some definitions. And one of the definitions that was proposed was a definition of systemically important derivatives clearing organization. And as proposed, the language did not take into account dual registrants, so that if you are, for example, the Options Clearing Corporation, you're registered with both the SEC and the CFTC, the way we had phrased the definition, if you are a DCO and you are deemed to be systemically important, then you are subject to this provision. And that was not as precise as it should have been, because it had the unintentional result of taking a DCO, a dual registrant, and even if their supervisory agency were the SEC, we would say you have to file the rules with us. And indeed, Section 806 says you file with your supervisory agency. So it would either be the SEC or the CFTC, but it wouldn't be both. So noting this issue, rather than building in a definition into this rulemaking, we decided it was better to just go ahead. When we do the DCO definitions, we will make the change there. Right now, nobody's been designated as anything. There's no confusion. We'll put the change in there, and then that will serve as a useful definition for all other references to the systemically important derivatives clearing organizations.
Okay, thank you for clarifying
And
that.
Commissioner Summers, it just as we use the word foresee and this says intend, I'm just sharing, I support this. I mean, it's not a.
No, my only clarification is which rulemaking we were going to fix this in. My other question is with regard to the 60-day advance notice of any rule change that would decrease risk for SIDCOs. And there were a number of different commenters that had an issue with waiting the 60-day time period. And so in the final rulemaking, we talk about how the SIDCO could notify the Commission in writing, or I'm sorry, the Commission could notify the SIDCO in writing that it does not object to the change before that 60-day time period is up. My question is with regard to the 10-day for Commission review, is it somewhere in between? It has to be at least 10 days, but it can't be more than 60? Is that how those kind of risk-reducing changes would be dealt with?
I think we have interpreted the 60 days as it's the statutory time frame, but we can always notify people in less than 60 days. And based on Title VIII, it would not preclude notifying people in 5 days or 9 days.
Okay, so it doesn't have to be at least 10.
That is how we have
Okay.
interpreted it.
Thank you.
Thank you, Commissioner Summers. Commissioner Amalia.
I have no questions.
Thank you, Commissioner Amalia. Mr. Staywick.
Commissioner O'Malia?
Aye.
Commissioner O'Malia, aye. Commissioner Chilton?
Aye by proxy.
Commissioner Chilton, aye by proxy. Commissioner Summers?
Aye.
Commissioner Summers, aye. Commissioner Dunn?
Aye.
Commissioner Dunn, aye. Mr. Chairman?
Aye.
Mr. Chairman, aye. Mr. Chairman, on this matter, the yeas are 5, the nays are 0.
I thank you, Mr. Staywick. I thank the commissioners, and I thank the team for their excellent work across divisions. Tom, now you get to go back and do real-time reporting and all that we need to do there. And Bella, you get to go back and do your CEF summaries and get things to the commissioner. And Phyllis, we look forward to, with transparency, maybe we'll address the clearing rules in late September, or the risk management part of the clearing rules, which would include this. So thank you all very much. At this time, I'd like to welcome Ward Griffin of the Office of General Counsel. Ananda, back again. Ananda, did you get any sleep last night?
Just a bit.
Yeah, not for 2 days. To present the staff recommendations in the final rule. Ward, there's a lot of ways that people start out the day when they're a team lead, but I have to say that as team leads go, you started out this day like no other team lead, maybe past or even in the future. But the email that we all got this morning, I mean, the public might want to know. Ward's email to all of us that somehow you had misplaced your 2 bow ties and the colors of those bow ties. Were you successful in retrieving those bow ties yet?
Unfortunately, no, but I'm glad you bring it up, as we know it's all being webcast here today. And if any of the members of the public happen to come across a couple of bow ties in downtown D.C., I'd appreciate the heads up.
I just want to let everybody know. What was it, orange and what?
Orange and blue, University of Florida colors, and another one was a variety of colors.
I see. All right. Well, I'm glad. I hope that you'll be able to secure those bow ties, Ward, and I thank you for all your hard work on this. But it's over to you, Ward.
Thank you, Mr. Chairman, Commissioners. I sit before you this morning to present the final rule titled Removing Any Reference to or Reliance on Credit Ratings in Commission Regulations and Proposing Alternatives to the Use of Credit Ratings. But before I begin, I'd like to take a moment to thank the Commissioners and your staffs for your thoughtful comments throughout this process. I would also like to thank John DeBoard of the Division of Clearing and Intermediary Oversight for his assistance, Andre Kirilenko and Steve Kane of the Office of the Chief Economist for their work with this rule, as well as our colleagues at the other financial regulators with whom we have engaged in interagency discussions of the issues surrounding credit ratings. Finally, a special thank you to Adrienne Jovez, who preceded me as team lead of the credit ratings team. The impetus for this rule arises from Title IX of the Dodd-Frank Act, specifically Section 939A of the Act. Section 939A requires agencies to take 3 actions by July 21st, 2011. First, each federal agency must review any regulation issued by the agency that requires the use of an assessment of the creditworthiness of a security or money market instrument and any references to or requirements in such regulations regarding credit ratings. Second, each federal agency must modify any regulations identified by that review by removing any reference to or requirement of reliance on credit ratings, and by substituting an alternative standard of creditworthiness as the agency deems appropriate. To the extent feasible, federal agencies should seek to establish uniform standards of creditworthiness for use by each such agency. Third, Section 939A directs each federal agency to report to Congress a description of any regulatory modification made pursuant to 939A. To carry out the directive of Section 939A, the Commission reviewed its regulations and identified several references to credit ratings. The identified regulations could be categorized into 2 groups. First, those that rely on ratings to limit how Commission registrants may invest or deposit customer funds. And second, those that require disclosing a credit rating to describe an investment's characteristics. On November 2nd, 2010, the Commission issued a rule proposal addressing 2 such CFTC regulations, and after considering the public comments received in response to that proposal, the final rule is presented for your consideration. The 2 CFTC regulations to be amended by the final rule are as follows. Number 1, Regulation 1.49, which places qualifications on the types of depositories in which futures commission merchants and derivatives clearing organizations may place customer funds. And 2, Regulation 4.24, wherein credit ratings are used to help disclose to customers the characteristics of investments. I'd like to take a moment and describe how each of those regulations will be affected by this final rule. In relevant part, Regulation 1.49 restricts the types of foreign depositories into which futures commission merchants and derivatives clearing organizations may place customer funds. Specifically, a non-U.S. bank or trust company must either 1. Have in excess of $1 billion of regulatory capital, or 2. Issue commercial paper or a long-term debt instrument that is rated in one of the 2 highest rating categories by at least one nationally recognized statistical rating organization. The final rule before you would remove all ratings requirements from Regulation 1.49 as the Commission originally proposed. Consequently, should the final rule be adopted, a futures commission merchant or derivatives clearing organization may only deposit customer funds in a non-U.S. bank or trust company if the non-U.S. bank or trust company has more than $1 billion of regulatory capital. Turning now to Regulation 4.24, the current regulation requires commodity pool operators to disclose to its customers the characteristics of the commodity and other interests that the pool will trade, including, if applicable, their investment rating. The final rule adopts the amendments proposed in November, which would remove the reference to ratings in Regulation 4.24 and replace that reference with the phrase creditworthiness. The preamble of the final rule before you reiterates the point that commodity pool operators may still choose to reference an investment rating to describe the creditworthiness of an investment in its disclosures. However, the commodity pool operator, as appropriate, should make an independent assessment of the creditworthiness of those investments. That concludes my prepared remarks. Thank you again for your time this morning, and I'd be happy to answer any questions that you have.
Thank you very much, Ward. And the Chair will entertain a motion to accept the staff recommendation on the removal of credit ratings.
So moved.
Second.
Thank you. I support the final rulemaking to remove references to credit ratings. Title 9 of the Dodd-Frank Act actually provided that all of, not just the CFTC, but other regulators do similarly. And this rule removes it from 2 of our regulations that Ward just described. I think that we addressed it in last week in one of the rules too. We did some rating agency piece, if I remember. Is that right, Ward?
There was a piece that was addressed actually in the Part 40 rule. There
Part
was a
40. All right,
was a
so it was
reference in
earlier today.
Correct.
Earlier.
That was in Appendix A of Part 40, the former Appendix A of Part 40.
And there is one other piece of this actually in a proposed rule where we have a proposed rule with regard to customer funds. So there's a piece in the customer funds rule. But I support this. I think you've found a way through this. I know some other regulatory agencies have a greater challenge with this, but I think that this is a good approach for us. Commissioner Dunn.
Thank you, Mr. Chairman. I support this, and I commend Ward and his team for putting this together. And Ward, just for your information, I keep a couple of ties in my office in case I spill something. One of them's a bow tie, so if you ever lose all 3 of the ties at once, come see me.
I do appreciate the offer, Commissioner Dunn. Thank you.
It's a heck of an offer because I'm not sure. I don't know about Commissioner Amalia, but I don't keep any spare bow ties in my office. But Commissioner Summers?
I don't have any questions. Thank you.
Commissioner Amalia?
Thank you. Yeah, I have conventional ties, regular ties, Ward. I don't have any questions. Well done. Thanks for your work on this. I guess I'm interested to understand what is being done internationally. We have, obviously we're not internationally banning credit rating agencies. Every day last week, I think I read a different credit rating agency having an opinion about our debt situation going forward. But it makes me wonder, are our rules similar to international rules going on this issue?
Well, certainly 939A of Dodd-Frank incorporated a restriction that internationally has, as far as I know, not been raised. And I know that in the course of our interagency discussions, there is, and speaking frankly, there is some question as to appropriate alternatives to the use of credit ratings. There is not a silver bullet, so to speak, that would apply to all asset classes, all types of investments, all entities equally. And so there has been an ongoing dialogue within and among the various U.S. Financial regulators with respect to appropriate alternatives. And so I know that dialogue is ongoing, but to your question as far as internationally, I'm not aware of there being similar restrictions in foreign jurisdictions.
Thank you.
Thank you, Commissioner O'Malley. Mr. Stawick, you don't have the bow ties either, do you? Do you maybe?
I
You
do
have
at
them
home.
But you have them at home. You might want to keep one for
I
board.
will now. I
right,
will do
thank
that,
you.
Mr. Chairman.
Thank you. Mr. Stawick, you want to call the roll?
Commissioner O'Malley.
Aye.
Commissioner O'Malley, aye. Commissioner Chilton.
Aye by proxy.
Commissioner Chilton, aye by proxy. Commissioner Summers.
Aye.
Commissioner Summers, aye. Commissioner Dunn.
Aye.
Commissioner Dunn, aye. Mr. Chairman.
Aye.
Mr. Chairman, aye. Mr. Chairman, on this question, the yeas are 5, the nays are 0.
Thank you, Mr. Stawick, and Commissioners. Thank you, Ward and Nanda. Thank you, Ward, that we can have a little humor at your email and expense and everything. But if we see
I
somebody
appreciate
with orange and blue, University of
Florida.
we'll know.
I appreciate
If
it.
Mr. Stawick's wearing that bow tie one day, we'll know. So, let me just see if there's any things I'm supposed to do, and because sometimes I ask unanimous consent at this point to allow staff to make technical corrections to documents voted on today prior to sending to the Federal Register. Sometimes that's just to make sure it's in the right format for the Federal Register. Without objection, our next scheduled meeting is on August 4th. And the subjects of the rulemaking presented at that meeting will be published at least 7 days before the meeting. We had calendared whistleblower, I think, for this week, but I think that we'll be looking, hopefully, that on August 4th, and we'll see what other things we can take up. I mean, we all know it because we have it in front of us, but to the extent people get comments back in on the swap data repository registration rule, I think that's a very important one. A lot of market participants have actually asked for that to be early so that they could be registered and the data maybe could start to be collected in these data repositories. We have a couple of other possible ones that are all in your hands. So we'll see if 7 days before the 4th we're going to do them, then we'll put them on the website. And I think we have 2 meetings calendared for September right now. So with that, I'll entertain a motion to adjourn the meeting and also congratulate, maybe we should do a motion to congratulate Bart Chilton on becoming a grandfather too. All
So
in favor
moved.
of that? Aye, yeah. We'll give him an official motion. On adjournment?
So moved.
Second.
All in favor? Aye.
Aye.
Commission stands adjourned.